ये शायद प्लग नहीं है,
नहीं है
चार्ज
क्या?
अच्छा है क्या?
चालू
हो रहा है। Very good evening to all our investors. Yet one more session, a webinar session for you from our side. This time we have invited Mr. Jatin Popar, who's sitting towards my left. Before beginning to the webinar, I would like to give a brief introduction about Jatin. Well, you all know what the topic is. It's about evil. What is evil and what are its benefits? What are the myths around it? Everything would be covered by the specialist Jatin Popat. So before getting into the product specific discussion with Jatin, I would like to give an introduction about Jatin. Jatin is a qualified lawyer and a company secretary. He has experience of more than 20 years in legal, succession, compliance, corporate laws. As a professional, he has provided services to more than 10,000 assignments of listed entities, banks, FIIs, MNCs, SMEs. He's the founder of WillGenie.com. WillGenie was established in 2014 and it's a unique service company for succession matters with an innovative technology solution. Hope I am right, Jatin. WillGenie has also other institution partners in India as well as international presence with US, UK, Canada, Malaysia, and Dubai as well. I think in the last 3 years, WillGenie has successfully catered to more than thousands of customers for online and offline matters. Jatin is also a founder of LegalGenie.com, which has a team of professionals like chartered accountant, company secretaries, and lawyers. LegalGenie is a popular name for under one roof professional service, including legal, company law, compliances, tax matters, etc. I think with that, Jatin, it's a new topic that we selected. The reason why we wanted to cater to our investors is not only on the financial need, but also the need to secure their financial savings, whatever they have earned through their life. I think the purpose of inviting you is that we have complete retail investors. We have more than 5.5 lakh investors who come to HDFC Securities for various financial needs. Yes, we do try to cater to them to all their needs. One such need, what we found out is the evil. So with that kind of introduction, I would leave to you, Jatin. I think the overall when we also decided this topic of evil, the frequently asked questions, I'm sure there are a lot of already more than 100 customers who is coming and popping out the questions. Why will someone? Why will? Why is that needed? They come and ask our relationship managers. Then the second thing is, what are the myths? There are a lot of myths surrounded under it. Even the most educated and even the professionals come and ask us, why Sampath? Can it be done evil? Can it be done in English? Can it be done with other languages? Can it be done offline? Is my signature needed? Is my signature on the digital signature? Will it be valid? There are a lot of questions which came out. So then we found out that yes, there is a genuine interest within our investors for understanding what this concept of evil. So that's why we decided that in the beginning of the financial year, let us start helping our investors to understand what this will is and what this evil is. Now over to you, Jatin.
Great. So thank you very much, Sampath. Thank you, HDFC Securities, for allowing us to share our views and thoughts about the succession matters. So basically, we are here to cover in a short span of about 30-40 minutes to explain the will subject, overall, as well as a few myths and how the evil works. So this is the basically agenda for today's discussion. So first of all, let me cover up on Sampath has just said why will. So everybody has a question. Will okay, will is something which is required for somebody else, not for me. So people are skipping those things. As far as we are concerned for the financial industry, people have been creating wealth, managing wealth, multiplying wealth, but the second part, which is a succession of those wealth, are always missed. And nobody has thought over, nobody has seriously given any effort to understand the subject. What will happen? What I have to do? Okay. So this is something which is really required to understand the need. So in our view, a smart investor would always start thinking about succession also, whether it's 45, 50, 60, whatever. So don't say that I'm aged, then only I'll think about this. So this is a very important thing which a smart investor of HDFC surely will start thinking about. It's a succession, right? So succession coming is the last phase of the financial wealth and management planning. After you earn, made a career, you multiply the assets with different products like mutual funds and so many other properties and all. So, but this succession is the one which you need to start thinking now. If a will is there, probably you can distribute your asset as per your wishes. Otherwise, please note, this asset will be distributed as per the succession laws which the government has made. So these laws for Hindus, for Christian, for Parsis and Muslims, they are different law which we call a personal law. So this is something which, if you have a control of your asset right now, if you wish this to be also to be done to distribute asset for your wealth, please do a will. Otherwise, it will be divided as per the government law which says equally for Hindus, similarly for other religions. This also could be one of the documents which one can make just to avoid any disputes or debonding or misunderstanding within the family, because if there is no will, all the family members have their own stories and discussions. There could be a chances of propping up of a lawyer or some legal professional just to create a debonding. So to avoid that, a written simple piece of paper of a will give a clarification to a family that yes, this is what my parent or my father or mother wanted to do, so let us distribute accordingly. So this is really a guidance to a family how to distribute your asset, and it can be a good. People have been creating wealth for years, 30, 40 years. They keep a bonding of the family, but one simple mistake, they will ruin their asset to some block way, or there will be a debonding. So this is something with a simple mistake of not creating a will could happen to your assets and your family. There are cases where the assets are there, will is not there, and people have to go and run around the court for bringing a succession certificate, which is costing more than ₹1,00,000. So if you want to donate something to government, go ahead and don't make a will. So if your will, which is very simple document, via email you can create in half an hour, so your family don't have to run for 6 months for bringing a succession certificate from the court and spending a lot of money. So this is something which one should keep in mind why will is required. There are people, most of the people are there which are into business side and self-employment, professionals, they've got their own business. All those people need to look at it that yes, business also need to have a succession. So not only the wealth that you created today, the business, if you don't have a proper succession, the future income which is coming to the business, your family, you are making a full stop there. So if you are smart, you also think of creating a succession for your business, whether it's a shop, you have a business, a factory, a company, or a partnership firm, you need to think over. And that is where a will also come in place. So even for your business succession, a will comes in a place. There are NRIs. For them, inheritance tax in India, it is already exempted for since
So Jatin,
85.
can I interrupt here? Sorry.
Sure.
So I think I liked what you said. It's very cost effective as well. What I could gauge from your what you're trying to convey.
It's just our e-will is 4,000 rupees, which is just like a one dinner one will spend it with the family, and effort required is half an hour. So if you bundle it, time and efforts and money, you will realize that if you want to give it 6 months hassle to your family to go to the court and bring succession with the cost of maybe ₹1,00,000, this could be a better way.
Oh, that's lovely. So you mean to say that it's the most cost effective,
Yeah.
at the same time hassle free way of legalizing whatever your succession plan, right?
Yeah,
Okay.
absolutely.
Okay, continue.
And there are, so I was saying that even NRI has a very good point to make a will for Indian properties as per the Indian law. So if they are sitting in US, UK, Canada, Australia, where there are good amount of tax they have to pay to the government as inheritance tax. So if they bundle the product, their assets in India and those country, they have to pay a big amount of tax to their government. So if they separate out, one will for their local country, one will for the Indian properties, then they can save tax on Indian property. This law is accepted globally. So it's a smart NRI has to create two wills. One is for the local property and one is for the properties which are located in India. So this is something for NRI. So this is overall few topics that we can share with you why will is required. So after that, there are so many myths people are avoiding to create a will by so many excuses or maybe myths. Few are there which I would like to share here, which we have heard during our last few years of practice. People are saying that this will is require a lot of stamp paper. So please note that India government has exempted a will from a stamp paper. India government doesn't require any money for making a will. So that is something which you will know. A plain paper will is legally acceptable till the Supreme Court. Again, there are people saying that, oh, I have to do a registration, I have to do some probate and all. So people don't know that registration of a will again is non-mandatory. It's optional. So in a family where there is a possible way of family member who could dispute, object for sharing, possibly those are the people may consider of doing a registration.
Okay.
So in our experience, 5-7% people have gone and done the registration of a will. So it's not much because people know that just simple guidance family will follow. No need to have an additional witness from the government, and it's not mandatory. So just because somebody is saying registration should be there, one should avoid registration. Just go ahead and make a will, and that simple will is acceptable till the Supreme Court. So that is a very simple myth people have that I have to do many things. People even ask that I have to do probate. Just they don't know that probate is required after somebody dies, and after somebody is asked whether objection is there, then the probate is required. So even probate is not mandatory for all the will. So one has to have a will, then only it can be challenged at all. At that time the probate will come in place. So these are the very silly type of myths people have in mind. There are people who say, oh, I am not that rich, I am a corporate executive, I don't have big business, I don't have big money, I don't have properties, I am not in business, I am not a super rich, I am not a Chennai. So why should I make a will? So what we are saying that for a will, it's not necessary that one should have a super rich. Even a single flat or an insurance policy or a demat account, it's an asset. So even if you that asset, if you want to distribute to your family, it will require a will. It's not necessary that you should have so many numbers, then only you should require a will. So it is really necessary for even a single flat. So what we are telling to the world that, okay, if you have a flat, you please think of a will. So these are a very simple thing which they should know. There are people who says, oh, I will do it at later stage. Once I cross 70 and all, when I'm relaxing, when I have nothing else to do, I will make a will. We are asking them, sir, is anybody has a date of expiry? Has anybody known date of expiry? Then what is the later date? So if you don't know the date of expiry, one can not predict that I am going to live for 70 years. So it's smart to make a will now. Maybe you can change after 5 years, every 5 years, and make it align it to your that type of requirement. So at least a simple one page of one simple will at any age, maybe at 40, 45. We have seen now corporate executives at the age of 40, they do very good planning to make a will also.
Okay.
So this is what a new trend we are seeing. The old age people, they are also taking the help of their grandchildren, their children to make will. We have so many examples of that. There are people who are saying, I have made all the property in joint names and nominations are made, so I don't need a will. So this is again a myth. A joint properties are always a sharing. So if you made joint property with your wife, so your wife has hold 50%, and it is your duty to at least say about your 50%. So it's not that she will take over the all once I die or something. So joint property is not a solution. You have to make will for your own asset, which is 50%, right? Otherwise, this 50% will be again distributed equally if you don't mentioned in a will. So it's not automatically that wife will enjoy everything.
So I think, Jatin, I think our investors would be more keen to listen to the last point. So I think one myth, the first myth is that it has to be on the stamp paper.
Yeah.
Itself is a myth, is an eye opener, I would call it. It's been historically believed that anything legal has to be on the stamp paper. The most important document, like a will, not necessarily has to be there in the stamp paper. I think the second point is, as you rightly said, it not necessarily it has to be registered. I think the third point is what you said, that even if, just because you have a joint holding doesn't mean that your wife or a spouse or whoever your joint holder has the legal right to inherit that. So I think that's really eye-opening, Jatin.
It's true. So, and even nomination, people just argue that I have done nomination, so I don't need a will. However, nominee is just a trustee. People don't know that any nomination, it is only a government is facilitating that nominee will be given the asset of the family, but he cannot own. He is not a legal heir. The government is saying that, okay, you collect your family asset in your name so that it is not gone to the government. So it is collected by a nominee, but however, he is responsible as a trustee to distribute to the legal heir. Now, legal heir may come through a will or a successor certificate.
Okay.
So nominee is not an owner. He cannot say that I am owner. That's again a myth which people don't know properly. So anyway,
So common man, it's a myth. Someone with a legal background, I'm very glad that we are having this for you to break this common myth.
there was one classic case where shares were, they were saying that it will go to the nominee, which is now overruled. So that was the only property which there was a dispute going around, that who is going to own shares. Nominee can own. That was the ruling by the High Court, which they have been now overruled. So today, all the property, whether flat, insurance policy, bank account, your demat account, your locals, everything, wherever nominee is there, just for the facilitating your family to collect the asset from those authorities. They cannot own it. So that's something which you want to tell. And so many rural side we are seeing that, oh, everything will go to my wife or my husband. Why should I make? They are the main, my better half in my life. So they are legally will own. It's again a myth. In Hindu succession law, if a male person dies, the legal heirs could be wife and all the children. So they got equally. So it's not that my wife will take everything and then she will decide. So that's a myth again. The last and one thing which you want to share, that people are saying, oh, will is full of hassle. You have to visit the legal professional. You have to spend time. They will ask a question. I have to think a lot of things about confidential detail I have to give. What money they will charge, I don't know. There will be a 3-4 visit I have to make. So these are the things they say they postpone the matter. And for that, this is what we have done with the HDFC. We have created a product called e-will, so which gives you 100% confidentiality. It's 100% legal will as per the Indian law. It is can be made in 30 minutes at your time, at your place. So sitting at peacefully on Sunday, beautiful morning, on a couch, you can just make your will with some details into it. So it's so user friendly. One can go on filling their slides and one will find a will. So there's no need of stamp paper, no need of any registration, no need to visit any lawyer, nothing. Here what we have done to share this knowledge by webinar is one way. We also put FAQ in 12 languages. So we have put FAQ books on website, something like this. So one can take those FAQ just to have a knowledge about what we are sharing now in any languages. If the parents or anybody in the house who are not familiar with the English, we have got in 12 Indian languages. One can download and show the parents that this is what will is. Because there is always embarrassing situation when one cannot tell the parents that will is important. So they can just give this such type of print which they can look at it, they can read it, they understand the subject and then they can do it. So
the dependency of knowing only English has been cracked there, you're saying. Okay.
And we know that today money is becoming more powerful than the relations. Brothers, sisters, they fight unnecessary because there is no will. So, and they know that there could be a fight. So the children, when they want to tell to their parents, they should explain to them, which is a very sometimes embarrassing situation to telling the parents that to make a will. So this is a better way. One can take a printout and just hand over. It's in a very simple language. So 37 questions answered in a very simple way. It has been answered by us on will subject. So it is one who can do this online, they can do, or they can give it to their parents. So this is something which we wanted to tell about MIS, which can encourage you to at least clear your doubts and then at least think as a smart investor to create a will so that your family has a peace and happiness even if you are not there.
Absolutely, absolutely.
So with this little knowledge, somebody say, okay, now I want to make a will.
How do you
So
do that?
next,
How do you do that?
What is
Okay.
the next?
So you're going to cover.
What-
You have covered all the myths which we are surrounded.
Yeah.
So now we're going to suggest our investors how do they make it. Now how do they execute that?
Correct.
So go ahead.
So then we have a question that what will is, what it contains, and where to make it. So these are the two things we would like to share you. So a will is a very simple document in written in any language. So maybe handwritten or maybe typed, both are acceptable as per the Indian law, but it is to be in writing. Oral wills are allowed only for some military personals and few Muslim community it is allowed. But otherwise, as per India law, will has to be in writing, whether it's a handwritten or it could be in any language. So it is a written document. That's a simple thing. It is to be made by a person who has a property, who is uh, not sick with the mental capacity. So somebody can make his own decisions without any coercion or force. They have to make a will.
So mentally
Sound. Somebody who are not in sound mind, they should not make. This happens when people
Or
age,
old, yeah.
Alzheimer, there could be a deathbed, and that time making a will is at all out of questions. There are famous politician case going around, which is today in the court of law on this subject, that somebody was sick and the will was made with
Without
sound mind. There was a medication going on, so that was challenged.
Okay.
So one has to really think that not to make a will at that age when you are not well mentally. Your medicines are going on. So this is where we are saying it should be. Secondly, it should be can be any language, which I have shared that it could be in any language. However, when you go for registration, in the local way, they may ask English translation. So that is something which one can decide later on. So will can be made in any language with a typewriting or handwriting.
Okay.
So it's basically even if somebody is not knowing English and one makes a will in the English, a person can mention that okay, I have read full to in language which is known, then also it is acceptable.
Okay.
So even e-will can be made for parents or somebody who are not knowing English, but there is a paragraph we insert that somebody, a witness, is explained in the local language.
The language which they understand.
And they are agreeing to it. Okay, so that also is problem. It has to be in a very simple language. We have seen some wills made by, I don't know, very expert type of legal personalities, a little bit of complexity and things are not very familiar to the people. Some people are making will with a contradictory language. Some people are making a vagueness. So these are all things that can be avoided when you write a will. One should not do contradiction. Otherwise, all efforts will be zero. Again, there will be fight within the family. So one person has made a will, is mentioning that, okay, everything will go to my wife. And then in second paragraph, he says, I love my son loves my car, I will give my car to my son. My daughter needs this jewelry, I will give. So this is contradicting. One way you are saying, everything will go to my wife, and then you start saying something. So this is what a very
so the utmost
simple
transparency and clarity has to be there in the will. If you have to your wife to inherit, then make sure what all things she has to inherit.
Correct, and you don't contradict. So, and even vagueness you should avoid. So these are the very simple rule for making a will, which our E will take care of all those things. Uh, when everything is there, when you start creating a will, it is better you mention the name of your family. So this is all a will document generally have. Whether you want to give it to them or not, that's something else. But it is better to make your personal name and detail, your family detail. That is where you have to mention in a will. The next is, if you have minor children, upon someone is guardian. So guardian will take care in if something happens to you when your kids are minor. So they will help those minor to take care of their life till they become major. So the guardianship is always preferred, and you have to appoint somebody who may be from relatives or friends. There could be a possibly you can appoint an executor. So executor is not mandatory again. So executor is a role which is playing a role to distribute your asset as per your will. It is to be distributed very nicely and in a time bound manner. So executorship is which we are saying it's not mandatory, but you have to appoint somebody, maybe a professional, maybe a family member,
Okay.
who takes care to distribute in timely manner. So this is something which are part of the will.
The basic tips, which is what you have covered.
Yeah.
Okay.
And then we have a saying that whatever properties if you own, you have to go on adding those property, whether it's a flat, bank account, land, your factory, your business, your jewelry, your locker. So you go on adding those properties one by one, one by one.
Okay.
And if it is joint, please mention that it is a joint property. Okay. So joint property, it is better to mention, and this list of the property will always give a good inventory to your family.
Okay.
So if you avoid giving inventory, it is also not illegal. But giving an inventory is good for your family, that they are aware.
So it can avoid the further disputes in the
Further
future.
dispute, and they are knowing that okay, these are the asset my father had. Because many a time parents, they don't disclose all their belongings and assets to family, and they feel that okay, they are aware of. But when they have inventory, it is ready for them where the money is lying, where the flats are there, what are the insurance policy, what are the demat account. So it's really ready to use. Then you can add witness's name. So witness name again is important. We have to add two witnesses in the will document. The bequest means you want to give asset to your family. So the wishes that has to come in a will. So these again a part of the will, that what you want to give to your family members, to how much. So there are ways of means. People are doing in percentages. People are doing asset wise also. So there are different ways people think that I want to give it 50% to my wife, 25% to my son, 25% to daughter. So these are the basic way people distribute their asset in a will. But there could be asset wise also. There could be clauses which one can mention about the residual. So many assets are there. You have got patch, you have got intellectual properties, you have got some things, personal belongings like computers, mobile phone, which you have not mentioned. It could go on residual. And even you can make one blanket clause for the future assets. So these are the two assets which you could generate in the future. One can make it a part of the will. And so beneficiaries are always you mention, it is better you also mention alternate beneficiary. So if you mention someone name to like a spouse, but may happen that your spouse living before you. So you should have an alternate beneficiary also, which is clearly mentioned in a will. So these are the basically a document a will can contain, and one can make it as simple as possible.
Okay.
The e-will has all the process where you go on making a will through slides.
I think very fair. Just to give a break to our investors and to catch up of whatever, because there's too many legal stuff coming in. I'm sure our investors are not that legally savvy to take up whatever inputs you are given. So I think to put it on a simple terms, simple layman's language. First thing, as I myself being a financially backed up guy. With knowledge in the finance various products, but when it comes legally, I think I'll be very candid and let me confess that I myself came to know that you don't need to have anything registered, then you don't need to have anything on the stamped agreement. I think that itself is the biggest eye opener, as I mentioned earlier as well. Then I think what one more point you rightly put across is the kind of clarity you need to have, the kind of, even it can be in any language, any 12 or whatever regional languages available which you are preparing with a sound mind is more of important priorities which you need to list out in the e-will, rather than trying to confuse too many things written in the e-will. It should be a simple one. It should be really as candid and transparent. It should cover all the aspects. Even just because somebody is holding on a property in the joint, it doesn't mean that she or he will inherit that
As a owner.
I think these are all wonderful points, Jatin. This might sound like very simple, but these simple point covers almost all the doubts, which I think the kind of questions which is coming forward also clearly says that our investors are keen to know about these simple facts. So now comes the important question. Is it expensive? I think you did mention that it's very cost effective. It's hassle free. Unlike, because Indian law as very clearly says that the number of times you need to go to the court, you need to knock the doors, you need to appoint the lawyer. So that's a mental frame of mind which is not true. I think you clarified. Credit goes to you completely, Jatin, because all you need is. Do you want to sound them the investor? How expensive, if I have to ask you? Evil.
So evil, as I said, it's not that expensive. It's equal to one dinner of your family on any Sunday. It's a 4,000 rupees that cost is there for you.
Plus taxes.
Plus taxes, yeah. So 4,000 is the price that evil is there, plus the taxes. So you can make a will. You can make a will every 3 years, 5 years, as per as.
So one good dinner equivalent kind of an expense is going to ensure your legal hair and your legally who you want to ascertain your wealth can determine that. Is very interesting fact. I think I'm sure people won't mind spending that 4,000 bucks on a meaningful expenditure, I would call, because ultimately whatever wealth you create through financial your expertise and knowledge ultimately needs to go into the right hands, would be everybody's first priority. I think with that, Jatin, I would like to move to a couple of questions. If you look at it, what they have asked is, few questions like, what are the fees, which you did certainly cover. Can you please, immovable property. So somebody wants to know, is it possible for me to do an immovable property?
Yeah.
Prepare a will for an immovable property.
Sure. So immovable property is your land, your building, your factory, your warehouse, your shop, your offices. All these things are called immovable property, even agricultural land. So all these things has to be a part of your will. It's very necessary. And many a times, if you feel that these are the very big properties and I need to register a will, you should go ahead. So making a will is must. Registration is secondary, it's an optional that you may think, and those services also we are providing as an offline if it is needed. So registration may be needed, but yes, all your agricultural land has to be part of your will.
Okay, I think that's fair. So I think you covered other points as well. They're asking that is English is the only thing that we need to prepare it through e-will, or other languages also. I think you covered. So.
Yeah, we are in India. You can cover as many as 17 languages, official languages are there. You can make any type of language in a will, and this will be acceptable in any court of law.
Okay, it doesn't require any lawyer's presences again. So the whole purpose of the e-will gets defeated. So you don't need, right?
No, basically, we as a lawyer, we have made this digitization as a tool to create whatever we think when we make a will, a drafting of a will. We have converted into an application. Okay. So the product that you get, a will, which is as good as made by a lawyer. Okay. So though we are not saying that you have to visit a lawyer, but the final will that will come on your table, it will be absolutely like made by a lawyer in a very simple language.
Okay. Okay, so I think that's what everybody's question, as I rightly said, a common man's question is going to be whether it needs to be registered. I think more than 20 people have asked the same question, should it be registered? I think time and again you have clarified that particular point as well, Jatin. I think we have covered fairly whatever features of the product. I think you covered the myths, what are the common myths surrounding the e-will. I think how do you apply, simple question, you need to come to HDFC Securities, you went into our online site. You can, there is a video, there are FAQs, and there is a way to easily how you can make use of this service, which is, as Jatin said, that it's as less expensive as having a dinner outside. So I think it's a great session, I would call. More than 2,500 to 3,000 investors have participated in this webinar, Jatin. I am very glad that you could make it as a professional with more than 3 decades of experience in this particular field, giving your inputs to our investors. I am sure that our investors would be benefited after this webinar. I think with that, I would like to thank you again on behalf of our investors. Over to you for your closing remarks.
Yeah, thank you very much, Sampath. And I'm sure that all the customers of HDFC will benefit from this webinar. They will at least look at this subject seriously now, and they should visit HDFC's e-will and start making a will at their own convenience at the earliest. Thank you very much for your time.
Thank you, investors, for participating. We will meet in another interesting session coming soon. Thank you so much.
Thank you so much.